And we are live. Welcome to Crypto Law TV. I'm the founder, John Deaton, and tonight's host. And tonight's topic, the Bill Hinman speech 4 years later. Tonight, we commemorate the 4th anniversary of the most infamous speech on digital asset regulation ever given by then SEC Director Bill Hinman. And people, this speech was a game changer in crypto in the United States. For example, take a look at that real-time chart of Bill Hinman's speech and the impact that it had on Ethereum's price and in the market. And this speech, 4 years later, has developed a legacy that the SEC and Bill Hinman did not bargain for. It's a legacy that is in political in nature, legal in nature, and ethical in nature. We're going to talk about all those topics tonight with our guest. My first guest, listen, what can I say about this guy? This guy's so good at explaining complex legal issues and making them simple and easy to understand that when I file a legal brief, pun intended, as amicus counsel in the SEC Ripple case, and people ask me, John, what does this mean? I say, let's ask Jeremy Hogan. So let's ask Jeremy Hogan. Welcome, my friend.
Hey, John, thanks for the introduction. That was very nice of you. I tell people that I'm only good at explaining these things because I'm not very smart myself.
Well, you know, you've developed a knack that I wish I had. You can really explain something in very short form period of time. But let's get right to the topic at hand, Jeremy. Let's travel back in time. 4 years ago from today, what did Hinman say in his speech that's so relevant?
Right. So I guess since I'm first up to bat on your guests, I want to set what was happening back at that time. Now we have to remember pre-June 2018, with Hinman's speech being in June 2018, pre-June 2018, there was not a lot of guidance from the SEC out there. So we're going back into 2017. The crypto world was really only a couple years old. The SEC really seemed to just kind of be getting its footing on how it was going to regulate this new industry. So really the only thing that was out there that was could be seen as any guidance was the Dow report. And really the Dow report just said, look, crypto industry, we know you're out there. We're watching what you're doing. Just because you call yourself a crypto project or just because you say that you sell tokens does not mean that the SEC regulations do not apply to you. So it was almost like a shot across the bow saying, this is the warning shot. From now on, though, if anything happens, we're going to come after you. So that's where everything was left in 2017, John. That's where it was. The warning shot was fired, and then there it was. Now, June 2018 comes around, and in that regulatory environment where there wasn't any guidance, only the SEC saying, be careful, we're going to get you if you do anything that we think is wrong. You get this speech from Bill Hinman, which just comes out of the blue as far as I could tell. I mean, it really was just a wild thing because what does he say? Of course, he gets up on stage. I think he's at the Yahoo Finance Conference or something like that. It's a big stage. And he says something about decentralization. Now, you have to remember that none of this had ever been said before. This was all coming out of nowhere. And I think that's the main key takeaway from that speech was, where did this come from? What are you talking about? Decentralization. So he comes up on stage and he says, look, looking at tokens, looking at ledgers and networks and digital assets, in my opinion, wait, I'm sorry, getting ahead of that. He doesn't say in my opinion. He says that if a network is decentralized enough, then it will be not deemed to be a security because it's decentralized and therefore there's no efforts of others leading to the profits from the sale of the token. And I actually have the part of the speech. Now he goes further than that, and I have the speech itself pulled up right here. So let me just read it verbatim from his speech from the SEC website. So not only does he talk about decentralization being a key factor in the determination of whether something's a security, but he goes further and he says, putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network and its decentralized structure, current offers and sales of Ether are not securities transactions. So that's your free pass. and it came out of the blue. And I'm sure everyone that heard it was like, what is this? And where is it coming from?
Well, you say out of the blue, Jeremy, because correct me if I'm mistaken. After this speech, every time Clayton or Hinman or anyone else was asked about a specific token, what was their response? Their response
I can't
was,
talk
we
about
don't.
a specific token. Yeah.
Right. So the question is, why give that speech on that day 4 years ago? Let me ask you, what were the actual outcomes since Hinman's speech in a legal or policy term?
So, I think of the Hinman speech as kind of tragic. And now that I've been in this space for a couple of years, I really think it is, because now you have this speech that comes out of nowhere and it says, we're going to look at decentralization as an essential element, almost as a add-on to the Howey test, right? If something's decentralized enough, then you're not looking at the efforts of others in order to create profit. So now you have, and there's every lawyer, I'm sure every securities lawyer in town at the time was talking about it. So now you have something that says, here's a roadmap, crypto projects. If you're a crypto project, this is how you don't have to register with us. So everyone's relying on that guidance. And now 2 years go by, and then you have the Ripple case. And then 2020 hits, and now we see that, well, actually, of course, Hinman's speech was just his personal opinion, and it's not official guidance from the SEC. So I really think of it as tragic, because you have all of these projects that are going along this route thinking, I'm doing the right thing. And now 2.5 years later, they realize, oh, I could be sued and just ruined financially.
Well, we've learned that that Jeremy Kauffman of the library case went in with a slideshow basically mirroring that speech and showing how the library token LBC complied. But let me ask you this. No one is more of an expert on reporting on the Ripple SEC case than you. What is the Hinman speech meaning? What's it mean in the Ripple case in general? And is it important for other than XRP and Ripple? What's its meaning or importance as it relates to the entire crypto space?
Right. So obviously the main use of the Hinman speech as far as Ripple's defense is in its fair notice defense, that it was not given fair notice, that what it was doing was wrong, or that it was illegal. So that's the most obvious use for the Hinman speech, because you have the SEC coming out. It was the SEC, of course, even though later they tried to receive that. So you have the SEC coming out and saying, this is how you comply with SEC regulations. And then 2.5 later, they change that and say, no, that was just his personal opinion. So that doesn't matter that you complied with that speech. So obviously there is a use for it in Ripple's fair notice defense. I think, though, I'm not sure if they're going to do this, but I think if I was Ripple's lawyers, I would try to work that into XRP is not a security as well, because I think you can really put Ripple, I mean, you can put XRP up there with Ether and how their networks are put together. And I think you can really make that comparison. And I think if you make that comparison, I think you're not only, I don't think the speech is limited only to the fair notice defense. I think you could possibly use it in order to make the argument that XRP is not a security, or at least the sales of it recently.
And then, of course, if XRP is Ripple successful, or XRP holders successful in making that case, then that's going to apply to a slew of other tokens that have been trading for the last, 5 to 10 years, don't you think?
Right. And that's the SEC nightmare scenario, that there is an appellate court out there that rules that there was not fair notice to Ripple, and then it loses regulation over all of these projects in theory, if you have an appellate court said that. So, I mean, the fair notice defense really is the linchpin in this case to an extent, because if XRP is deemed not to be a security, and that's from an appellate court, there is some effect there on other projects. But really, the fair notice defense is the one that brings all of these projects under that umbrella of that defense, and could really, well, it would help the community, it'd help the crypto projects, and it would hurt the SEC.
All right, Jeremy, what I want to do, I want you to stay with us. I'm going to bring in a fella. He's a professor at George Mason Law School. He's also senior advisor at Messari, which we all know is the crypto industry's leading market intelligence platform. And he's the only person on tonight's show that's interacted with Gary Gensler and Hester Peirce and the SEC commissioners in his previous role on the advisory committee of the SEC, and that is my friend J.W. Verrett. Welcome, J.W.
Good to see you, John. I think I just missed you at Consensus, man. I heard the legend was around, but I never ran into you down there.
Well, it wasn't me. It must have been Garling House they were talking about, or somebody. But let me ask you, Jeremy and I were discussing this speech and its impact that it had on the crypto market. What I want to ask you is, it appears to me after Bill Hinman gave this speech and Bitcoin and ETH got clarity, that the rest of the market was left in purgatory, so to speak, to borrow a word from a CEO relevant in this case. And it seems to me that Gary Gensler, and you'll know more than I, he almost welcomes this regulation by enforcement. And I want to get your take on it and what you think about it.
Well, you mentioned library. I mean, I think what was done to that project is just atrocious. I mean, they went in with open arms. They went in transparent. What do I do? How do I comply? And it was a game of gotcha. It was more of the Gary Gensler gotcha. And that's the gotcha he's doing against exchanges right now, right? This game of surely out of 1,000 tokens, one's a security. And if one's a security and you're not a registered exchange, I gotcha, right? Yeah. Which one is it, Gary? I'm not going to tell you that. That would be legal advice for me to share that information with you. I can't do that, but I gotcha. It's unfair. It's bad regulation. Yeah. And right now, all of us in the industry are waiting for the next shoe to drop. My hope is this defendant that I admire, Ripple, these folks that I admired, Library, they fight. They fight all the way to circuit court. They fight all the way to SCOTUS, and then we bring more cases going forward. Pre-enforcement challenges, potentially, seeking declaratory judgments about the SEC's interpretations here. Let's not wait for the other shoe to drop. I mean, I think the right move here is to take the initiative and to take the fight back. DC Circuit is not deferential to the SEC on administrative law challenges, pre-enforcement challenges. I think that's where we need to go from here.
Well, you advise, I mentioned Masari, and you teach securities to young lawyers. You advise entrepreneurs. I know Jeremy's doing some of that as well. But how would you state the current state of, do these companies know what the rules are?
No, it's not clear. It's not clear. It's also, aspects of the Howey test are not clear. The guidance is not guidance. The guidance seeks to grab as much jurisdiction as possible, the prior guidance. It's not clear what activities looking back will be matched together such that the statute of limitations is kind of extended. You take subsequent sales and subsequent, potentially exchanges are worried about whether they're being treated as being involved in a distribution, an initial distribution or secondary distribution, even though they're not even they weren't part of the initial distribution. It's not clear the extent to which airdrops count as sales of securities. I would argue, at least on my reading of the law, airdrops are not a sale of securities. And the predominant, at least the current method of airdrops, don't implicate the securities laws at all. But there are securities lawyers at the SEC who will tell you, no, we're going to bring some more cases anyway, just to see, just to try it out and see. I would like to see clarity there. I think probably the only clarity we're going to get is by fighting. That's the only way we're going to get what we need. But I think if we do, I think we can win some of these cases.
Yeah, you mentioned airdrops. You may not know this, but XRP holders, Flare Network provided an airdrop on a specific period of time for XRP holders to get the Spark token. And so the impact is, if there's a result in the Ripple case that XRP is a security, if that were to happen, what's that make the airdrop from Flare that was based on the XRP token? You know what I mean? So I think you raise a great point. Let me ask you this. Both of you, Jeremy, I want to bring you in on this. Both of you advise entrepreneurs today on securities, regulations, on, token issuance, all those things. Jeremy, I'll go to you first. If an entrepreneur comes to you today and says, this is what I want to do, would you accept Gary Gensler's invitation to come on in and talk to the SEC? And then I want JW to answer it from his perspective.
Nice to meet you, JW, by the way. John, I spent the last 20 years trying to get away from law school professors, and here I am, full circle. So, here's how I would answer that, and this is the sad truth. JW just laid out I think, what the US regulatory environment is like. And I would contrast that with, I just talked to a lawyer that's out of Dubai. And this is how it works at Dubai. Dubai has 4 licenses, crypto licenses. And they say, what do you want to do? And you tell them what you want to do. And they say, here's the license that you would be under. You want to sell an NFT? Here's an NFT license. You want to be an exchange? Here's an exchange license. And you have to pay some money and you have to give them some information. But it's very clear and everyone knows what they're licensed to do. Now, so when someone would come to me and say, Jeremy, I want to do a project. I want to be able to sleep at night. I can't tell them stay in the US, especially in the crypto world where you have people from all over the world, employed in these projects. There's really no need to be in the US. So do I tell them, look, why don't you talk to the Dubai lawyer I just talked to and see if you want to set up shop over there versus staying here? And that's the sad truth. And that's what I would honestly tell people if they came to me right now.
What about you, JW? What are you telling people that you're advising? Not getting into your attorney-client privilege, another issue relevant in this case, but what's your take on all this?
Well, I focus my work in helping to defend clients, less transactional, more defense. But I think what I understand, the dominant advice is, I agree with, which is largely what Jeremy said, which is get the heck out of the United States. If you can do everything overseas, do it overseas. Yeah. Don't do it here. And it's sad. That's an incredibly sad state of affairs, Yeah,
it's very sad because I interviewed Jeremy Kaufman, the library CEO, and he flat out says, hide your stuff, because they went in there, gave every token distribution on a ledger, gave a PowerPoint, did everything you could do, was an open book. And then, of course, 4 years on the dot, got sued. And he said, how can we comply? I'll dissolve the corporation. I'll do anything it takes. And they said, no, you register or you go away. And so anyways, that's where we're at. I would be remiss. I need to ask you, JW, because you're more involved with policy than I am. And you're talking to congressmen and senators. And what do you think of the Loomis and Gillibrand proposed bill? And, is it a solution and a good solution? What are your thoughts on that before you check out?
Sure. There's a lot of good ideas in there. It's a big bill. It's 70 pages long. So there's a lot of good ideas in there. It's bipartisan. They're trying. They're listening. They care about crypto. So they're always going to be my friend for that, Senator Loomis and Senator Gillibrand. The specific section about Howie needs some work. I want to keep working on it. The Laura Shen's show Unchained mentioned my criticism, my quick criticism, and talked to one of the drafters of it. There was a little back and forth. I advise you all to listen to Louis Cohen from DLX Law's interview with Laura Shen. Look, here's the basic takeaway is I like Hester Peirce's solution and solutions on that simple safe harbor. It's simple. It's clear cut. There's a time exemption to allow projects to sufficiently decentralize. It takes time to decentralize. I like that. The statutory language in the bill is too complicated. And once it starts getting complicated and you need judicial review, judicial interpretation, you empower the SEC, because then they're going to slow walk a case like that. Or they're going to seek, there's a provision in the bill that says you have an exemption, but a judge can take it away. If the SEC brings an action, they're going to threaten that, use it as a cudgel. So it's just too complicated. They tried, and their heart was in the right place, but it's too complicated for my taste. So I want to keep working on Title III of that bill, but the rest of it, most of it, I love. I think there's a lot of good stuff on tax in there, a lot of good stuff on custody for banks and stuff like that.
My final question for both of you is this. JW just mentioned Hester Peirce is safe harbor. And this is the 4th year anniversary, show on this speech. Instead of giving this speech, why didn't they just adopt that safe harbor where it said you have 3 to 5 years to meet these markers? And Ripple, if you don't meet these markers, or ETH, you don't meet these markers, then you have to register. If you do, it is, great. And you go on and you're sufficiently decentralized, or whatever language. Why was that not adopted under Chairman Clayton? He had the votes. He had Elad Roisman and he had Hester Peirce. I don't know. Do you know the answer to that question?
I got to pass that one to JW. I don't know. I mean, obviously, I think you're going to talk more about this later, but obviously, I think that it's come to be that we know now that Mr. Hinman probably had some ulterior motives for that speech, maybe jumped the gun, and didn't have the backing that maybe he needed in order to really get the commissioner's views out there. But I don't know.
JW, any thoughts? I know you have a hard stop soon.
Sure. I know Jay a long time. I disagreed with him on his approach to crypto. Believe me, I had a lot of private conversations with him during the ICO era where I said, I don't like some things happening in some of these ICOs. I love to get a crypto-specific regulatory regime. Hester's safe harbor hadn't been out yet. I wish it had. I would have been arguing for that. But I had a lot of tough conversations with him because it was the one area where I just glaringly disagreed with him. I don't know Hinman. I don't know what Hinman was about, so I can't tell you that. I think Jay's heart was in the right place. I don't think he had any nefarious intent. I think he was just risk averse. It was a new thing, and he was a classic regulation guy, and he didn't want to try anything new. And it was a mistake, and it was the wrong decision. I don't think there was anything unethical about him. I just don't know Bill. I mean, I don't like the optics of what happened here. What I've seen so far from what Empower has taken out, it seemed like he didn't comply with the ethics requirements, and that's a problem. I don't think that's on Jay. I think that's on Bill. I don't know why. I don't know why he didn't do more. Give us the guidance and the clarity that we need. I wish they had.
Well, listen, I thank you both, JW and Jeremy, for sharing your thoughts tonight. I hope to have you on soon again. All right. Thank you so much.
Thank you, John.
Thanks, John.
Appreciate it. What I want to do now is we talked about this Hinman speech, this legacy having political nature. Well, that's going on now with the proposed bills. We talked with Jeremy Hogan about the legal implications, but there's this ethical legacy that is very active, that's lingering, that when Bill Hinman gave this speech, you all saw the chart and you heard Jeremy Hogan say, scratch his head. Why did they gratuitously, all of a sudden, one day, they'll never talk about a token. They'll never talk about a specific platform. But on June 14th, 2018, Bill Hinman's going to get up on that stage and he's going to say, Bitcoin is not a security. ETH is not a security, and talk about these things and then never address another token thereafter. Why? Because from that moment, you scratched your head. Like, why are they singling out Ether? It had an ICO. He said, well, forget the fundraising, but how does it apply to any other token? And we never got answers. And so people started asking questions. People started looking into these potential personal conflicts. And it's fair to say that in this case, there are what I have called massive conflicts of interest and gross appearances of impropriety. We're going to talk here in a minute, but I want everyone to take a look at this email from the person in charge of the ethics office at the SEC to Bill Hinman. This is courtesy of my next guest, Jason Foster of Empower, but read it. Right? It lets him know you have a bar under the criminal financial conflict. You are not allowed to even talk to Simpson Thatcher. And what did Bill Hinman do? He met with them 3 more times that we've documented from after receiving this stern warning that he could be in violation of the criminal conflict laws of the United States. Okay, so I want to bring in a couple people to talk about this ethical issue, and that is Eleanor Terrett of Fox Business, who has covered these questions around the Hinman speech, perhaps more than any other mainstream news journalist. She's an expert in the objective facts of this case. She's written an opus, very lengthy investigatory piece, and then a follow-up piece. And I want to welcome a guy that I'm a big fan of. I didn't know of him until what he did at Empower, and that's Jason Foster. He is president of Empower Oversight, a government watchdog group in Washington, D.C., who sued the SEC. And I want everyone to know, unlike me, Jason is not an XRP holder. He doesn't own digital assets. His job is to oversee ethics and issues related to government. And so welcome to both of you.
Thanks for having us.
Thanks for having us.
Ellie, I'm going to turn to you first. Will you give us a rundown of the facts? What are the ethical questions surrounding this Hinman speech?
Well, I've said it before. I think there are many conflicts of interest here. And when I first started digging into this, as you know, Charlie and I were a little careful in our way forward with this. We said, okay, we're going to look into this objectively as journalists, and we're not going to take what everybody tells us too seriously. We're going to look into the facts. We're going to look into everything that people are showing us. And we just, we did that, and we did the research, and we talked to the people involved. And just when we laid it out and everything started to kind of come together and we saw the timeline, and we're like, wow, like that's interesting. That's a very, I'm not saying that there's, like Charlie and I always say, I'm not saying that there is any kind of corruption here. Charlie says confluence doesn't equal causation. But I will say, after many months of investigating it and writing about it, it's clear that there are many conflicts of interest here. And it's not just Bill Hinman, but Bill Hinman has, as it would turn out, as it appears from these documents that Jason and Empower have turned over, have gotten for us, it's pretty glaring, especially with the communications with Simpson and Thatcher. I will say, when I first saw that, I kind of thought, like maybe these meetings with his friend from Simpson and Thatcher, Josh Bonney, could be very casual, just going out to lunch, just catching up as friends. We don't know their, personal background together. We don't know if they were talking business or if they weren't. But you have to go back and look at the emails from the compliance office saying, Bill, you have a financial interest in this company and you cannot have any meetings with them. So that to me is just very, that's glaring. And, I know Jason has some thoughts on it as well, but there's lots of things going on here. And I feel like there's more that comes out every day. And I'm personally interested to see what other documents the SEC is going to turn over, because, with the Freedom of Information Acts, we are, on the road to something pretty big here.
All right, I want to bring Jason in. And Jason, Ellie alluded to something. She alluded to that you've learned and others have learned that through the FOIA request that you issued and have litigated, that it was determined that this wasn't a regular pension that Bill Hinman was receiving, but he was an active, ongoing profit-sharing partner, which meant the better the firm did that same time, simultaneously, that he's an officer at the SEC and a government employee, that he has a ongoing financial interest. Is that my understanding correct?
Yeah, that's what we learned from the documents when we, when we finally got the SEC to actually start turning them over, which of course we weren't able to do until after we filed our lawsuit.
All right. Well, first I want to come back to that, Jason, but I may not have said it right. What is Empower Oversight?
So Empower Oversight's a nonprofit government watchdog group. Like you said, I had a career on Capitol Hill for over 20 years, doing investigations and oversight work for members of Congress, for committees of Congress. And then about a year ago, on July 2nd last year, I launched Empower Oversight to try to help and basically do the same kind of work that I did on the Hill for years and years, which was investigate government wrongdoing, corruption, and help improve the independent oversight of wrongdoing, both in the corporate world and in government.
All right. You said that you submitted FOIA requests. Summarize for us what you were seeking initially.
Yeah. So what when we became aware that there was this great controversy with folks like yourself and others out there, arguing that, this last minute enforcement decision right at the end of the previous administration to file this lawsuit, smelled, and there were all kinds of people making all kinds of allegations that there were ulterior motives, that people might have had financial interest in doing it. That's the kind of thing that someone who looks at, wrongdoing in government, that piques your interest. And so what we, and the Freedom of Information Act is a powerful tool that can actually ferret out, and get some facts on the table, from a public interest point of view, from somebody who doesn't have any dog in the fight one way or the other. And so, what we did was we said, well, look, people are making these allegations. These allegations undermine public confidence in the integrity of the SEC. People are claiming that the SEC officials acted for ulterior financial motives. Well, let's just ask the SEC for documents regarding communications between these senior officials and the folks that they used to work for and then went to work for again after they left the SEC, who reportedly had a financial interest in the enforcement action that they took. And, let's see if that issue was engaged inside the SEC with the ethics official, because there's a whole office of people who are supposed to help police this within the SEC. So let's just ask for all the communications. We saw in the Ripple case that there were, deliberative process privilege was a big hurdle, to a lot of the information coming out. Because if you're focusing on what's the SEC's policy decision going to be, or enforcement decision or regulation decision, then a lot of that is going to be legitimately deliberative process. And it's going to be hidden. It's going to be subject to privilege and not turned over in litigation. But if you're doing a public interest request, and what you're looking at is potential corruption of government officials, it doesn't matter to us what the SEC's internal deliberations were about what crypto regulation ought to be or what their enforcement strategy ought to be. We were just looking for facts. Did Mr. Hinman have communications with his former firm? Did he have communications with the ethics office about whether he should have communications with his firm? Given the documents that we found, another key question is, of course, did the ethics office know that his former firm had an interest, potentially had a financial interest in the speech that he was giving, and was that signed off on? It's hard to believe, given the evidence that we've seen about the advice they were giving him about not to even communicate with his former firm, that they would have signed off on, oh yeah, you can give this speech knowing, that the firm, could financially benefit from the regulatory clarity that you're deciding to give to this, to these two tokens.
Well, it sounds like, and we're going to talk about that, it sounds like to me you weren't asking for anything controversial through these FOIA requests. So, but what was the SEC's initial reaction? Because in the introduction, I said you actually had to sue the SEC for this stuff.
Yeah, well, their initial reaction was to ignore us. And then when they finally did send us some responses, some of them turned out to be false. So they told us they didn't have any responsive records. After we filed our lawsuit, we started getting documents, and we finally started getting some corrections to those previous assertions that they didn't have any records. And, we fought with them about, our initial request named, what we sought was, as I said, communications between these key officials and their former employers through future employers, communications with the ethics office. What we learned is that, once we got those communications with the ethics office, that there was as you've said, there's very clear advice. You can't be having these communications. And when you put that in the context of the speech, it seems there's a clear failure here that nobody connected the dots at the SEC. It doesn't look like the people who were in charge of making sure that Mr. Hinman didn't violate his ethical obligations, didn't succeed in doing that. They allowed him to participate in this speech. And so the question is, did they know? Right. Did they know about the implications of the speech for his former employer?
You're 100% correct. Let me ask, I want to bring Ellie on this. Ellie, and if you can't answer a question, feel free to tell me you can't answer. But we're sitting here, we're talking about these emails that went to Bill Hinman. Can you say whether or not you've reached out to Bill Hinman for comment? Has there been a comment? Are you privy to share any of that?
I can't share who I've talked to, because I talked to a lot of people off the record, but I will tell you that we reached out to every single person involved in this opus that Charlie and I wrote, every single person that we've been talking about, and they were okay with what we printed back in November. So
okay,
can't say yes or no, but
I understand. But as far as I know, Bill Hinman has never come out to correct any of these things, allegations that I've made, where I haven't accused him of violating a crime. I said maybe he violated Title V, maybe he was in violation of the criminal conflict laws of the United States, but to my knowledge, he hasn't come out. And so Jay Clayton was asked a question about, this, and he said, I can't talk about ongoing case. And I want to make this clear to everyone out there. There is no ongoing case about the ethics in the Ripple case. They're not litigating the conflicts of interest of Bill Hinman. So it is possible for Bill Hinman, for example, to come on record and say, this is what happened. I don't believe I violated any ethics. I screened my speech with the ethics office. I had them screen it before. I submitted it before. They didn't come back to me. There's none of that. You're not aware of any comments like that where he refutes any of this, are you?
No. And I almost wonder if maybe the SEC lawyers are telling him just not to say anything because they think maybe it'll mess up their defense. Because, obviously they went in saying, this is your personal opinion. He's in his deposition on record saying, this is my personal opinion. But now the SEC lawyers are doing a 180 saying, actually, it was the opinion of corporation finance. I will say I've talked to a few insiders at the SEC who knew Bill personally, and they've told me that lovely guy. And obviously they're going to tell me that, but he also is just very kind of by the book, and they told me this. So he is a straight shooter.
Which book are you talking about? The Ether book or the ethics book? All right.
They tell me he's a straight shooter, and he would not have done this intentionally. Maybe he wouldn't have given the speech if he wasn't told to give the speech. And for this person, these people that told me that he probably didn't even know that he was in the EEA. And I'm telling you this because that's what I've heard. I've talked to people in the SEC. I've talked to people outside the SEC who are, who were former employees there. And they kind of tell me the same story. I have not gotten anything from anyone that says, Bill Hinman is a crook. Bill Hinman was in this for himself. Bill Hinman is a bad person. So just from my reporting and for the people I've talked to, that's what I'm hearing. But
well, listen,
maybe an important point. Come out, but
I think that's an important point to follow up on. That he, as you say, he, whether he knew or not, that's why we pointed. The issue still remains. The SEC has an entire ethics office that's supposed to help people like Mr. Hinman avoid even the appearance of a conflict of interest. And whether there was an actual conflict of interest or not, we now know from these documents that, at least with regard to his former firm, anything directly involving them, there was an actual conflict. That's what the ethics officials said. But with regard to the speech and the connection to the EEA, that's what the ethics office is there to help those officials do, is to protect the public confidence in the integrity of the process by making sure that people don't engage in activities that creates these kinds of appearances. And so, that's why, I don't know if you want to talk about my request for the Inspector General to do an investigation. That's why we sent that request to the Inspector General. We're
definitely going to do that. My only response, I've never accused Bill Hinman of being a crook, but I will say, Ellie, that I'm sure at some point someone said Bernie Madoff was a stand-up guy at the firm and at the office. Okay. But anyways, when sins are committed in hell, there's no angels for witnesses. Let me just put it that way. Now,
but where, to your point also, then yes, then where was the ethics office? I know the general counsel's office was included on those emails, but why weren't the ethics office included on it? And was that just an oversight on someone's part, or was it deliberate? It's something we don't have an answer to yet, but it's something that's worth pointing out.
Jason, I'm a big fan of Empower and what it does. And I want for the people out there who dismiss this as a conspiracy theory, there's real evidence that there was a conflict. Whether it's intentional or not, that's yet to be seen or found. However, if you could just briefly talk about what you've sent and referred, because that came from you, not John Deaton or anyone tied to this case.
Right. So, when we got the records that showed the very clear advice from the ethics office, as I said, it pointed to a potential failure of the ethics officials and the entire ethics review process to again, as I said, protect the SEC from this appearance. It's bad for everybody if nobody trusts the SEC and thinks that they're all just in it to line their own pockets and right. So, that's a bad thing for everyone all around. The SEC doesn't want that. Nobody wants that. And that's why we have these people whose job it is to help protect the institution and the senior officials against that. And so, we were bucking up against, and still are, resistance from the SEC in terms of complying with our FOIA requests. They have stopped producing documents to us. They keep asking the judge for another 30 days, because they're hiding behind, well, we've got to coordinate with Simpson Thatcher and see if they have any confidentiality objections to documents. And, meanwhile, they're not doing the searches that they had agreed to do, to look at, when we first sent our requests in, there was a question about, well, we don't know who all these entities are. You're asking for all communications with these entities. We don't know who's associated with these entities. Can you give us some names? So we gave them a long list of names, and they said, okay, well, we'll do searches for these names. But then they refused to do them. And they're now holding that out as, they're not going to do them. And, but that goes to the point we're talking about. They're saying, well, we don't know who all these people are. We don't know these relationships with the EEA, who's associated with the EEA or not. And so, if the ethics office wasn't aware of that, then that may point to where the failure is. So we're running up against this, brick wall trying to get documents through the FOIA process. So we said, well, look, there's an inspector general at the SEC. They have the ability to do internal investigations. They have full access. They don't have to fight for documents. They don't have to litigate for documents. They don't have to do FOIA requests. They have statutory right of access to read every email in the SEC that they want to read. So they can get to the bottom of this very quickly if they want to. So what we said was, well, let's just tee it up for the inspector general. And we'll say, well, look, clearly there's a systemic failure here. That's, again, it's bad for the SEC. The SEC leadership and the SEC Inspector General's office should both want to figure out how to keep a controversy like this from happening again in the future.
Well, thank you for bringing it up, because I keep scratching my head. When the appearance, let's forget actual impropriety for a minute. When the appearance of impropriety rises to a level that it destroys public confidence in the agency, then actual impropriety has occurred. And my question is, why wouldn't the SEC want to clear this up? We're not asking them to do anything other than, were these rules followed or not? But
well, they should. They should want to clear it up. And then if the inspector general decides to act on our referral, then they could go and, as a part of a review of the failure of the ethics review process to stop this, clear public controversy from occurring, they could get all of the documents almost immediately that we are seeking, in terms of all the communications with all the named individuals associated with all the entities with the EEA, et cetera. And they could go through and review and know very quickly whether Mr. Hinman or others were having direct communications with these folks. They would have access to things that's going to be very difficult for us to get access to. They could get access to, they have subpoena authority. They could get access to people's cell phone records and find out, well, was he using a personal cell phone to have a communication with someone, something that you can't get through FOIA. So, so asking the IG to take a look at it, it just made sense, because it's in the interest of the agency. It's frankly in the interest of Mr. Hinman if they can clear this all up and say,
Sure.
He didn't have any nefarious communications.
Absolutely.
It's in the interest of the public. It's in everyone's interest for the IG to do something.
No, I agree. Ellie, let me ask you, do you believe that the news coverage and pressure from XRP holders and, the internet sleuths, as they've been described, that have helped, do you think they've had any impact on the mood inside the SEC or Mr. Hinman himself?
So just before I answer that, I just want to quickly circle back to,
Sure,
Charlie and I have been reporting quite a bit on Gary Gensler himself and the mood inside the SEC lately. And we had an article come out a couple weeks ago where we said that, he is, for all intents and purposes, he's a very, he drives a hard ship, Gary Gensler. He came in and he's got an agenda and he wants to get stuff done. And to the point where the SEC union is complaining that they can't take vacation because they have such a big workload of things to do. So, in terms of the FOIA requests and having the SEC internal attorneys, staff people comply with that, I would imagine they're struggling to just kind of keep up with the aggressive agenda of Gary Gensler as well. So, hopefully we'll get some movement on that. But I feel like it's a lot of just stuff going on inside the SEC and everybody's trying to just make sense of it and get on a timeline. So I did just want to point that out because we know that, some people are unhappy. In answer to your question, yeah, I do think that the SEC is sitting up and taking notice of the XRP community. I mean, look at the look at the sleuths. They've done so much work. They've uncovered all these videos. They've uncovered all these, prior statements from people's statements that they probably don't even remember that they made, right? And then it's all here on the internet to see. And it's like, well, actually, these people they're saying one thing, but actually back, 3 years ago when Hinman made his speech, he said another thing. Jay Clayton said something else. They keep talking about we, right? And I'm a big, I've noticed that the most when my kind of digging through with this. It's seeing the videos and the speeches where Hinman and Clayton and the SEC officials, they refer to we. This is our opinion. We think that Bitcoin and Ether should not be securities. And it's like, well, if you're not referring to the SEC as a whole, the agency that you represent, then who is we? So I think, that digging up those videos and kind of holding people accountable has done wonders for this investigation. And I hope that Charlie and my reporting has kind of brought some light to it as well, because I know we're one of the few mainstream medias who's picked it up and stuck with it. And you too, John, of course. I mean, you know better than anyone, like in court the other day when, the SEC lawyers won't even look at you. They know who you are. They know that you're calling them out and they know what you're doing on Twitter. So yeah, I 100% think that the XRP community and the kind of rally around this thing has gotten noticed.
Well, you said something, and I want to bring Jason on this because I'm not sure you're aware of this, Jason, but Ellie, you said that, the SEC is paying attention. Well, certain senators and congressmen are paying attention because Senator Mike Crapo of Idaho, responding to a constituent who went on Crypto Laws Connect to Congress, made this request for these inquiries and conflicts issues. And Senator Crapo cited Jason's referral of evidence in the reply. And so I think that, Jason, you tell me what impacts that have on you? Were you even aware of that?
Well, I mean, obviously, if you have members of Congress who are, if they were, I don't know what impact it has telling their constituents that, but it certainly would have an impact if members of Congress would ask the IG to open an inquiry. I mean, the IG doesn't have to respond to us. We're just a private nonprofit. We sent the letter. We said, hey, you should look at this. But if they got requests from senators to take a look at it, because senators are getting requests from their constituents about it, if then that has an impact. I mean, that's one of the factors. IGs are independent. They're supposed to be independent of their agency and of Congress. They make their own decisions. But obviously, if something is a major controversy and members of Congress are asking about it, it makes it more likely that they're going to open up an inquiry. We've gotten no response to our referral thus far, and they might open an inquiry and never tell us, right? But they might very well tell a senator who asks, so that they can, if nothing else, tell their constituents, hey, it's being looked at, and there'll be a public report at some point, and we'll get back to you when the investigation's done.
Ellie, let me ask you, you're aware of Jason's referral to the IG. Is Fox Business or yourself or Charlie planning on reaching out to ask if they have any intention in responding to Empower's referral?
Yes, and if we haven't already, then we definitely will. I need to go back and check my emails because I ask the SEC things quite frequently, and they have been better at responding to me lately. We've got a nicer relationship going on now. So, I will definitely reach out, and they usually come back to me with a no comment. We will not comment on ongoing investigations. I know this is not part of the official ongoing investigation, but they usually kind of come back with a no comment or something along those lines. So yes, I will definitely reach out on the progress of that. I think it's great, everything that you've done, Jason, in terms of the FOIA requests and really getting them to be accountable. So kudos to you.
Well, I went on record to say that Empower oversight and Jason's FOIA litigation is the best FOIA litigation that I've seen, and I've seen several of them. And so hats off to you, Jason, and the nonprofit you run and what you're doing, because you really are doing the people's work. I'd like to say that Congress and senators are always doing the people's work, but I know that that you are. So thank you, Ellie, for what you're doing as an independent journalist. Continue to do it. I want to thank you both for appearing, and hopefully we can do a follow-up show down the road.
Love to. Thank you, John.
Thanks. Okay, so we're going to wrap up, but I want to I want to follow up real quickly in conclusion of what Jason said. He said that the IG can reject or ignore his request, but cannot the Congress and senators' requests, especially those on the oversight committees. You have two banking committees, financial service conduct committees of the House and the Senate. Well, I'm proud to say that through Connect Congress on the Crypto Laws app, we've contacted all 100 senators, all representatives, and they've sent 50,000 messages related to this. And last week, my office sent out to every member on the banking committee in the House and every member of the Senate banking committee, simple letter that said, will you make an inquiry into whether or not this speech was in fact screened for conflicts? And I'll tell everyone out there, I know the answer is no. And I know the answer is no because it's very simple. You don't have to be a genius to figure this out. You read the speech and it gives Bitcoin and it gives ETH regulatory clarity. So in a screening process, it would simply be this. Well, Bill, you're giving Bitcoin and ETH some great news. It's going to impact them. Do you own Bitcoin? Do you own ETH? Do your family members own Bitcoin or own ETH? Let's talk about your ongoing relationship with your firm. Is there any connection to Bitcoin or ETH? Oh, there is a connection to ETH. Your law firm's a member of the Enterprise Ethereum Alliance. Bill, you can't give this speech. That's how it would have went down. If the SEC wanted to still give that speech, okay, it just couldn't be Bill Hinman because it violates the rules. Valerie, the czar of crypto, could give it, right? Amy Starr could give it. You know, Jay Clayton really couldn't give it because we know his conflict issues with his law firm Sullivan and Cromwell representing Consensus and others. But someone at the SEC who had no conflict could have given this speech. And so these are simple answers. So we're going to be reaching out through social media and other ways to these congressmen, to these senators on the banking committee. We're not asking for much. We're not accusing anyone. We simply want to know were the rules followed, because I don't believe they were. And the final comment I would say is take my hat off. I wanted to bring a few of you internet sleuths on, but we just didn't have the time. And I didn't want to rush it because I want to give you the due justice that you deserve. I'm not going to name names because I'll miss someone, but I plan on doing a show on decentralized justice where I can bring some of you in the XRP community, and some of you don't even own XRP, but you just believe in a level playing field in government. And the final thing to say is I know that there's blood on the streets in the crypto market. I can share with you that some of that blood's mine, but know what you hold, keep the faith, and I'll see you soon.